So members, our first order of business is to hear testimony from the Office of the Attorney General. When I'd originally set the operational tempo for the committee, because Senator Hinojosa and I had been working on border-related issues in the interim, and while each of you gentlemen are familiar with challenges at the border, my intent was to have the 5 main agencies, although there's 13, the 5 main agencies with border responsibilities, to come in and get the committee up to speed, to get the members that had not been doing any of the interim work that the committee had done, to get y'all up to speed just on a relevant common picture of the situational overlay of where we are with Operation Lone Star and what each of those agencies are doing. 2 weeks ago, when you held the gavel, Senator Flores, we were unable to get the Attorney General's schedule because he is a busy man to get those parallel, but we're able to do that today. So at this time, I'd like to call Attorney General Ken Paxton to come testify. And let me give a little bit of some logistical items, if I may. As the Attorney General is approaching. Witnesses, please be sure to register using the electronic witness registration system accessible on the tablets located in the hallway just outside the hearing room. If you have written testimony and also wish to speak, please provide your written testimony and bring it forward when you're called upon to share it with the assistant clerk or messenger at each end of the dais. If you do not wish to speak but have written testimony, please provide that as well to the messenger directly if you've not already done so. Please note that as highlighted in the posting for this hearing, you should also send a digital copy of your testimony to the clerk of the committee. So when you hear your name, please join us at the table down front. Those instructions will apply during the bill hearing portion. The Attorney General has invited testimony simply for the purposes of catching up to our first hearing because of his schedule. So with that, Chair's called Attorney General Ken Paxton. If you would, please introduce yourself and the agency you represent, state your name, and welcome, Mr. Attorney General.
Thank you. Good morning, Chairman Birdwell. My condolences. I lost my mother 2.5 years ago, so I know what that's like. So you're in our prayers.
Thank you, sir.
Vice Chairman Flores and Senator Blanco. For the record, I am Attorney General Ken Paxton, and I have some brief remarks. Thank you for your invitation to discuss the border crisis and its profound impact on our state. There are few issues more critical to address on behalf of Texas and the entire nation. Since President Biden took office, Americans have watched in horror as the federal government pursued a doctrine of open borders at any cost. This administration routinely enacts immigration policies that violate the Constitution. Their agenda has enabled and emboldened drug cartels, worsening America's epidemic on drug deaths. Their policies have enriched human traffickers by encouraging an influx of aliens to enter the country. These cartels are now making an estimated $13 billion every year. By the way, that's up from just 2018, where it was about $500 million. The economic burden imposed on the people of Texas is now estimated at nearly $9 billion a year in education, healthcare, law enforcement, social services, and other costs to support illegal aliens in our state. President Biden is callously indifferent to the costs and consequences he has imposed on the American people, and particularly the people of Texas. Because of the costs forced on the state and the administration's shocking disregard for the United States Constitution, my office is leading the fight against the onslaught of illegal federal policies. We are engaged at this time in over 50 lawsuits with the Biden administration, 16 of which are specifically related to border security or immigration. As appalling as the border crisis is, Texas legal challenges have successfully halted numerous destructive policies that would have made it even worse. We successfully sued to end Biden's pause on deportations of illegal immigration when he first took office. We actually filed that lawsuit on the third day of his taking office, and we had an injunction by day 6. We successfully halted the administration's attempt to impede ICE arrests and deportations by imposing new enforcement priorities that coddled entire classes of criminal illegal aliens. We successfully challenged President Biden's attempt to dismantle the highly successful Remain in Mexico program. Several times we successfully challenged the federal government's effort to open the floodgates by scrapping Title 42, and we defeated their effort to expand the Deferred Action for Childhood Arrivals program. We have numerous other cases pending, and I'm confident we'll prevail in many of these. As Attorney General, I will do everything I can to improve public safety, uphold the rule of law, and protect the people of Texas Mr. Chairman, I commend you and this committee for your efforts to look at this and to consider the issues affecting Texas.
Thank you.
So with that, open to questions, and I also have my assistant here, Ben Wilson, who
Okay. Does
identified.
Mr. Wilson have his own testimony? I'm happy to recognize him, or if he's here as your resource witness.
He's here as my resource
okay.
witness. How's that?
Okay. I just wanted to afford him an opportunity to speak if you had a
Did you want to say
particular,
anything?
if you have a particular addendum you wish to add to
who you
that.
are,
But
what you do.
it's not a requirement, but I don't want to be discourteous either, so.
I appreciate that, Senator.
Would you pull the microphone up to you? State your name, whom you represent.
My name is Benjamin Wilson. I'm a Deputy Solicitor General, and I'm here, as just stated, on behalf of the Attorney General as a resource witness.
Okay. Let me start the questioning in this way, if I may, Mr. Attorney General. Don't know if you had the opportunity to read. A lot of people don't necessarily read interim reports, but one of the sections that I put in our interim report for the committee was what we thought were the operative cases, not just what is written in the Constitution, but the operative cases that constrain or provide the guardrails of what states may do as it relates to immigration or border security more broadly. Those operative cases were some in the 70s and 80s, and then ultimately culminating in the Arizona decision in 2012. Can you provide just an overlay of, we know what, that in Article 1, Section 8, Clause 4, which is where it says the federal government shall have a uniform system of naturalization. That is the paragraph that gives the federal government the immigration responsibilities that it has as primacy. But, and I'll use this analogy, that if we're playing baseball, what are the areas between the first and third base line that we get to operate in without intruding or supplanting the federal government? So what are the dynamics of the ball field that we're on? I know it's not a game, but
Yeah.
the ball field that we're on as it relates to court decisions that have expounded upon constitutional specifics.
So the preeminent case is, as you know, U.S. v. Arizona, which was decided during the Obama administration. And I know Ben's read the interim report and knows some of the other cases better, but the one that we are most frustrated with is U.S. v. Arizona, because it confined, basically preempted state law that somehow conflicted with or potentially took part of the field of the federal government. And that decision was written by Justice Kennedy. Justice Roberts joined. 3 of the liberal judges joined, and Justice Keegan had to recuse herself. So effectively, it would have been a 6-3 decision. At the time, I don't think anybody realized the impact of that decision. I'm not sure the court realized the impact of that decision. But what that did was Arizona had stepped in and tried to pass laws similar to what the federal government passed. And those laws were designed to protect the citizens of the state of Arizona in a way that the federal government wasn't doing. And unfortunately, the court's ruling, by saying that the state couldn't step in and pass these laws, put these states in a really horrible position, much like we're in now, where the federal government can pass a law and then decide not to enforce it, pass another law and not enforce it, and then we supposedly as a state are unable to enforce similar laws and protect our citizens. So as we've watched that play out over the years, and certainly particularly over the last 2 years, the consequences of that decision are obviously horrifically bad, whether it's drugs or whether it's human smuggling, whether it's just the cost to the state of Texas for the onslaught of illegal immigration that's occurring as a result. I've thought a lot that there's no way that the court could have realized the consequences of their decision. And in my opinion, their decision didn't make a lot of sense. It doesn't make sense to me that the federal government can pass a law, then not enforce it, and then say, sorry, you can't enforce a similar law. So I have been saying this for 2 years, that we ought to do what we can to try to overturn that decision. We've got a different court. We've got the best chance we've ever had to overturn that and give the states the ability to protect their citizens. Because if we can't do it, then we leave our citizens unprotected in various ways. So Ben, I know you've looked at some of the other cases. You've read at least some of the interim report. You have comments on some of the other cases and how that affects where we're at?
I'd be happy to speak to any other particular cases, though I certainly agree with you that Arizona v. United States is is the case that sets the field for present purposes.
Okay, okay. Because I know when we studied that, it said essentially that all the state can do from an immigration perspective is that we can check immigration status at booking in and as it relates to providing people to, or referring people to Border Patrol, or I guess in this case ICE, if you have somebody that you've detained, charged, and then there's the criminal process. Is that a fair assessment? Because otherwise you can't, there's things that you can't do that you're specifically precluded from, as you mentioned in your remarks.
So I know that it's challenging to really understand exactly what we can and can't do based on that decision, because it's not just that you can't pass things that are sort of in opposition to federal law or that's automatically preempted, but then if it's determined that somehow it's in the playing field, that case said you can't do that either. I don't know exactly what that means. The only way I know to do this is to test it, and we've got a couple of ideas on how to do that. Your bill does that. There may be other ways that we can also test it and find out where the court is and what the parameters of that decision are.
Yeah. Let me ask some. This may be something of an ethereal conversation, but there are some areas of the Constitution I want to get your legal particulars, because we, when we take our oath of office, the first thing, the laws of, the Constitution of the United States and the laws of this state, and so the U.S. Constitution is always first. So, we take an oath to two constitutions. The federal authorities take it to one, but. We talked about what the state may or may not do. Article 4, Section 4 it says the United States shall guarantee to every state in this union a republican form of government and shall protect each state of them against invasion and on application of the legislature or of the executive when the legislature cannot be convened against domestic violence. I've had some individuals tell me that they think that, okay, since the federal government is not making that guarantee of security, that the state should act in place of or supplant the federal government. The way I read that, there's kind of, I think to your frustration you mentioned a moment ago, there is nothing, and this is why I think the Supreme Court made that decision, there's nothing in there that says if the federal government's failing, then the state can supplant the federal government on federal responsibilities. The state may only do what is state law within those parameters, which I think is what we're doing with Operation Lone Star.
Right.
I wanted to get your
I think your assessment's right. There were some cases. There was a few cases back in the 90s where this invasion clause was tested out. There's not a lot of information on it, but there's clearly an invasion. But is there an invasion that connects to the Constitution in a way that the states can do something about it? That's a difficult question, and I think if you look at the case law, it looks like it would be in a situation where you have a foreign entity, not like the cartels, but an actual sovereign nation, and there's not time for the federal government to act, and the state can step in and protect their borders from a sovereign entity. The issue of whether it could be like the cartels is, I think, far less certain. And I'd say the case law, some of it says it's a political question, and then others specifically say, I think there was one case that specifically said that would not be applicable to the invasion clause. So I don't know, Ben, did I get that right as far as summarizing what little case law we've been able to find?
Yes, sir, I think that's right. To add just a little bit of color, various states brought lawsuits under the invasion clause in the 90s. Running from about 94, 95 to 97 when they were decided in the courts of appeals. And I'd be happy to provide citations if you'd like, but all of those cases were ultimately rejected by the courts of appeals. Mostly they were decided on political question grounds. That is to say,
meaning what?
Meaning that the cases were non-justiciable in federal court. Because the question as to whether there was an invasion was committed to the political branches under the.
So it should have been Congress deciding, not the judiciary.
Congress or the president, yes.
Because we talk about original intent. And I'm not trying to be terribly ethereal, but when you talk about original intent, as a military professional, I think probably what the
That's
founder-
you, not me.
That-
Just
Yes, sir,
clarify.
but in a retired crispy status. But I think the founders, given at the time of the writing of the Constitution, without the modern technologies today that space-based intelligence and the like, I think the founders probably intended for an invasion to mean infantry, cavalry, artillery, and logistical supply train formations, kind of like what Santa Anna did in 1836 when he crossed the Rio Grande. That's probably what they had in mind. I mean, it's why we had in the early days of the country, you had coastal artillery units, because you wouldn't know if anybody at sea was out there till they break the horizon line. But when you look at, we've had over 6 million people come into the country since January of 2021, just in volume and numbers alone, and that 6 million is across the entirety of the southern border. But we've had 6 million people. That's more people than many of our states have in them. And at that pace, I mean, that's already more than Harris County coming into the country. And so is an invasion based upon the mode, i.e. military, or is the invasion based on population? Kind of like the difference between the Senate and the House. One's based on the U.S. House, and one's based on population, and one's based on sovereign entity. And then the cartels are not state actors. We learned that during the September 11th timeframe, not to invoke September 11th, but we started using the terms non-state actors. And the cartels are not a state actor. But they're clearly, I mean, the governors declared them a terror organization. There's some questions I'll ask about that and what that means, but they're not a sovereign entity that's operating under the Geneva Convention in the sense of an invasion and going from a peacetime operation to a wartime operation. So that's the challenge.
Well, there's also another one, and it's one I've thought about a lot. If somehow this invasion clause could be implemented at a state level, I'm not sure how much difference it would make, because the real problem here is we've got a partnership that was established on day one of the Biden administration, where he signaled to the cartels by saying, we're not going to deport anyone. Hey, bring as many people here as you can, and we'll let them in. And that's effectively what happened. And so that's why the numbers of the human trafficking numbers are at $13 billion a year as far as profits, because they don't. In the past, Border Patrol has been able to stop a lot of the illegal immigration, and under the Trump administration, you can see the numbers were way down because they were actually returning people. In this case, the cartels are bringing them to Border Patrol. They're not hiding. I mean, this isn't like they're hiding. Most of them are not hiding. They're being directed to come to Border Patrol, and Border Patrol they're more of a logistics group, not a security group, and they are processing people. And so even if you had some ability to call up the National Guard, which I don't think would probably work because the president would immediately nationalize them, I don't know how you stop the real problem here, which is the participation in the partnership between the Biden administration and the cartels. And that's where most people come. They claim asylum. It's the magic word. It's the password, asylum. And the way that was handled in the Trump administration was, under federal law, it says if somebody is claiming asylum, they either have to be detained before their hearing, or they have to remain in the country they would pass through. They can't come in until their hearing. The Biden administration, this is what our lawsuit is about, is not doing it that way. They're not following that particular law. They're just transporting them all over the country, and then we lose track of them. So even if you declare an invasion, I don't know how you would stop the federal government, because that's really where the partnership is.
Well, in Article 1, Section 8, Clause 10, that's the one that talks about invasion, and it's the no state shall, without the consent of Congress, and that's the fulcrum between state operation and federal operation. Lay any duty of tonnage, keep troops or ships of war in time of peace, or enter into any agreement or compact with another state or with a foreign power, or engage in war unless actually invaded or in such imminent danger as will not admit of delay. It is silent on who gets to decide the invasion. Is that the question? Because the governor's declared one. I think it's completely legitimate and worthy of such a declaration.
Yeah.
But based on what I think you said a moment ago, and the case law that you talked about in the 90s, does the governor? It would seem to me that the governor gets to decide that from an implied perspective from the Constitution. But I think what you were saying that that is unknown at this point. It would have to go to court to determine whether the state gets to decide it's been invaded.
I don't think there's Ben. Tell me if I'm wrong. I don't think there's any case law that has ever looked at that issue, unless I'm.
To the best of my knowledge, that's correct. When in the 90s, when invasion clause issues were raised, those were basically states going to federal court, and the states would say, we have been invaded and should be either recompensed or should have additional authorities. And as we discussed before, courts basically said those questions are non-justiciable. I am not aware of a federal court that has passed on, something along the lines of, the state has hereby declared an invasion and will be taking the following actions.
Right.
Yeah. So presumably, at this point, the governor could and has declared an invasion. I don't think that's been challenged, as far as I know. Is that
Right.
true?
But see,
Not to my knowledge.
Yeah.
I would think that if it may not be justiciable, but I believe the governor has that authority implied in the section of the Constitution. Because as this note shall, without the consent of Congress, and then you go through that list and it says, unless actually invaded or in such imminent danger as will not admit of delay. And it also says we can't enter into a compact with another state unless invaded or at such imminent danger you cannot admit of delay. Because of the nature of the circumstance, the way that reads to me is, we have specified and implied tasks. The specified task is you can't do it without Congress's permission unless you've been invaded or that you're in such imminent danger as you will not delay. I mean, 100,000 people dying of fentanyl every year, that's how many September 11ths?
It's a lot.
In 4 years we'll surpass the number of casualties in World War II. That's what you're talking about here. But so I think it implies the governor has that authority to do so. The challenge, I think, is let me extrapolate a little further, if I may.
Sure.
In making the invasion declaration, it now means that, based upon this reads, you may not enter any agreement or compact with another state or a foreign power or engage in war unless actually invaded. The governor's declared an invasion. That means we can enter into a compact with other states. But the way this reads to me is that unless the other state we might compact with also declares the invasion, let's just pick next door to the governor of New Mexico. If New Mexico doesn't declare an invasion, the way this reads, they're still under the permission of Congress because they haven't declared an invasion. Am I reading that correctly?
I think you're right, but this is part of the frustration we're dealing with every day, and what you're dealing with. We're in a place we've never been before. We have more illegal immigration and more ignoring of federal law than we've ever had as it relates to immigration, and so we're in uncharted territory as far as knowing what states can do, because states have never had to wonder or really test this. So I think part of this is going to be, we're going to have to figure out where are the areas we want to test. And that's part of why I've been saying for 2 years, we should test US v. Arizona. We should test to see if the states can protect themselves given the circumstances that we're in that are so different than anything we've ever been in before. And because of what you just talked about, just the fentanyl crisis alone is worth considering, especially if you're like me and kids who have died young kids who've died who had no idea they were taking fentanyl. So it's a horrible problem that we're dealing with that we've never had to deal with to this level. So I don't know, Ben, if you have anything to add to what I just said, but I think part of it is we just don't know until we get to court and test it. I do think there are things we can do to try to keep it more likely than not that we're going to win or that we have a better chance of winning. And I think that's some of the things we've thought about, how we could make some changes. We could suggest some things that would allow us a better chance of winning versus losing.
Okay.
Wouldn't guarantee it because we don't know.
Yeah.
I think that's right. I think the reading of the plain text that you're discussing sounds right to me. But it's certainly true that this is uncharted territory.
Yeah. Would such a compact have to be with another border state? I mean, it's not exactly germane, but in my Natural Resources Committee, we have a compact with the state of Vermont. Now, we had to get permission from Congress because it has to do with the low-level radioactive facility waste. But the states aren't contiguous. Would the states have to be contiguous here?
So I don't think so, only because, I've been saying this, we're all border states now. Because of the transportation, the administration is flying people all over the country. They're not even asking permission. They're just dropping them off. I've talked to, just in Texas, talked to our police officers in Dallas who are telling me that, buses come in, people get off, they disappear into the night. They drop them off in the night. And that's happening all over the country. They're just being flown in and dropped off and they disappear. So I think there's a pretty strong argument that they don't have to be contiguous or next to the border, because while Texas is more affected than any other state and border states are more affected than other states, it is true that the Biden administration is moving people around and it's affecting largely every state.
Yeah. You mentioned asylum earlier. My understanding of asylum was that it was always, and this is a federal question, but I want to get your expert. Asylum was always a question of, I think based upon UN protocol, asylum was always requested in the neighboring country, not I live halfway around the world and I'm going to get to Mexico as quickly as I can and request asylum that way. Or, if I've been to El Salvador and Nicaragua and been, that asylum was in the next neighboring country based on UN protocol, not this is the country I want to go be in, therefore I'm going to go claim asylum there. Can you expand on the understanding of asylum, that particularly because it's become the password?
Yeah, I don't know that answer, but I do know this, that in the past, about 14% of those seeking asylum got it. It was 12 to 14%. It was based on political persecution or religious persecution. So most people that went through the process were not found to actually be deserving of asylum, and they were sent back. Now, they just say it. These hearings, they don't happen for 2 or 3 years at best. People don't usually show up to them. And so it is a password. The idea of actually following some law and what asylum actually means, whether it's international law or whether it's federal law, it's kind of a joke. I mean, it's not really real because most people are not showing up for their asylum hearings, and they're so backed up because there's too many people. Do you know about whether the contiguous country thing is applicable in the actual question of whether you can qualify for asylum?
I can add some color to that. I'm certainly aware that in the past, the United States has imposed, has reached safe third country agreements, things like that, with countries that people transit through that require I believe, that require them to apply for asylum, individuals who wish to apply for asylum to apply for asylum there. I'm generally given to understand that you're correct as to the treaties, but I do not think it is an out-and-out requirement of federal law that you apply in sort of the first country you transit through, a neighboring country. That said, much of the asylum system from a federal level is based on executive discretion, and so there are various things that previous administrations have required, like remain in Mexico or like applying for asylum in a safe third country, that my understanding is, as a general principle, the Biden administration is not doing.
And by the way, we know what works. We saw it in the Trump administration that the Remain in Mexico program tied with Title 42 tied with stopping catch and release, and tied with building a wall, the numbers of illegals dropped significantly under the Trump administration. And then within a year, I think under the Biden administration, when they sought to eliminate all the things that were working, the numbers increased to, I think it was a 300% increase in 1 year, and those numbers continue to go up. So we know what works, and I'm pretty certain that the Biden administration knows what works, and that's not what this seems to be about.
Yeah. Let me ask one more question, then I want to get to the members of the committee. If we successfully test with this legislative session, put something in law that would successfully test the courts, Article 3, Section 1 of the that's the Article 3 is the section that created the Supreme Court, and then for the Congress to create lesser courts. And I won't pull it up and read off my Constitution app, but it's the one that says that the Supreme Court shall have original jurisdiction where in cases that involve a state, does the state have the ability to pursue the federal government? Is this when you say you want to test this, or does the federal government have to sue us? And because what I'm looking for is the time frame of getting from district court, Fifth Court of Appeals in New Orleans, and then the Supreme Court taking the case. What, 4 years, 5 years?
No, it could be, but it could be less.
Could be less. And I'm just wondering how long the state can.
So,
wait. I mean, that's the
provision you're talking about. We sue other states. We're required by the Constitution to sue them at the U.S. Supreme Court. So, when we sued, some of these Georgia or whatever, New Mexico, we have to go directly to the Supreme Court. We've done that often. When we sue the federal government, we typically start it in district court. Okay. In this case, if you pass something like this, we wouldn't be the ones suing. They would sue us, trying to get some type of injunction to stop us from enforcing state law. And then we would step in and say, no, we have a right to do this. And then the game would be on. It would depend on, where they sued us. I can't predict where they would sue us, likely somewhere in Texas. And I can't predict what judge we'd be in front of. So,
but from a time frame, perspective, short of presidential elections that have to go to the Supreme Court, in 2000 or short of something like that, I assume we're talking a 2 to 3 year.
It's probably right, but that doesn't mean the law won't be in effect. They have to. It's a pretty high standard to get an injunction. You have to show irreparable harm, that you're likely to win on the merits, and let's say they pick a court that's, maybe not favorable to us. We lose. We're going to appeal that directly to the Fifth Circuit. Then they're going to appeal that directly to the U.S. Supreme Court. So it's going to go. That part of it's going to happen relatively quickly. So if we're successful, if the Supreme Court or the Fifth Circuit rule in our favor, then that law stays in place until we go through that long process of going from district court trial to appeal to potentially U.S. Supreme Court.
But the way Article 3, Section 1 reads is that it says if a state is a party, it's really state against state, not
That's
the
correct.
state's a party against the federal government.
Yes.
It has to go through the normal rather than an immediate original jurisdiction.
Yeah, we have 52 of those going on right now, going through that process. We also have several state against state. Those went directly to the Supreme Court.
Okay. Members, questions? Senator Blanco, you're recognized.
Thank you, Mr. Chairman. Thank you, Attorney General. I want to go back to the discussion about invasion. As you recall, on August 3rd in El Paso, there was an individual who murdered 23 people in Walmart. And prior to murdering these folks, he had posted a manifesto online saying that there's an invasion of Hispanics in this country. So a little sensitive to the word invasion. So my question, and it's an interesting conversation because obviously we're having a constitutional conversation. So I'm curious, when was the invasion clause written? What year was it written in the Constitution?
I think it was written during
Part of the original
Original
Constitution. so it would be, 1789.
1789. And I asked the question because were there any federal immigration laws in the Constitution at the time when that word invasion was written? Or I guess my question is, what year was the first Immigration Naturalization Act?
I don't think it was 1789. I
No,
don't know what
I
year.
believe those date to the mid 19th century.
Right, okay. I asked that because I think context is important. And I think that as I'm trying to understand, and we're trying to understand the original meaning of invasion, and we didn't have laws limiting immigration when the invasion clause was written, it's important to note that the interpretation of the founders may have been different given how currently invasion is
Sure.
applied to individuals illegally crossing.
No, I think that's a reasonable assessment. I mean, we're in a different place than they were 200 years ago, and I don't know that they would have envisioned where we're at now, and that's why we're struggling with
Yeah.
what that actually means.
Okay.
There's
Appreciate
not been a lot of tests. There's been very little testing of it, other than the few cases we referenced in the 90s.
Right. Thank you very much. Appreciate
Sure.
it.
Thank you. Madam Committee Director, if you'd recognize Senator Hinojosa has joined us, and Senator Flores, you're recognized for questions.
Thank you, Mr. Chairman. General Paxton, welcome.
Thank you.
Good to see you.
Good to see you,
And I
too.
appreciate everything that you're doing.
Thank
And
you.
we look forward to working together to be able to make our Texas more secure. So back to we're going to go back to this invasion. Yes, I've kind of, with the framers of the Constitution, when it first talked about invasion, it was a different world. They just won our liberty from a monarch, and we were free, and hence all our amendments constitutional amendments were written to guarantee certain freedoms, or right to freedom of speech, bear arms. So the invasion at that time, I think one could reasonably say that invasion what the framers had in mind was a military invasion. And so are there any court cases that define, and we're in a different world, I understand that clearly.
Yeah.
We have, this what's going on here is totally unacceptable. But is there any court cases that you know of that define or invasion as either military or social, or give a definition to what that means in the courts?
I think there was one case, and Ben, tell me what that was. It was in the 90s that defined it more as a military.
Sure. There was a case out of the Second Circuit. It's called Padovan v. United States. It's 82 F. 3rd 23. It cites James Madison in the Federalist Papers, in addition to a couple of other sources, to make the point that, at least at that time, the Second Circuit held that an invasion basically was a foreign power for a nation state.
So, and thank you for that. I guess it's a different mindset. Yeah, when one thinks of invasion, you think generally of a military, but not a social one. But even so, even if whether it's social or whether it's military, generally when you think in terms of an invasion, you're thinking about whether it's the federal government, the state government, are pretty much lined up to resist that invasion. And what complicates this matter more is when you have our own federal government, notwithstanding our Border Patrol and all those that are in the field that are equally as frustrated, but when we have our own federal government being a party to what is occurring, it kind of makes it not like a unilateral invasion, but rather it complicates us in declaring that we're going to resist something that our own federal government. It's like fighting your own. The family's going to go to war, but you got your members of your own family on your side of the fence.
You hit the problem that I struggle with, because most of these people are going to Border Patrol. The Border Patrol are not our enemies, right? They're trying to do their job, and they're being directed to do it a certain way that doesn't necessarily follow federal law, and they know that, and they're frustrated by it. But the challenge would be, we declare invasion, what does that mean practically for dealing with what the major problem is here, which is this asylum issue, where we would have to have some type of direct conflict with Border Patrol? That doesn't make any sense. So it makes the invasion issue more of a subset of the whole. If you declared an invasion and somehow the state could actually execute and stop the invasion. Even with that, you'd still have the major problem of most people are being taken by the cartels willfully. I mean, this is all, it's a partnership, and everybody's part of it. The people that are being transported, the cartels, and the Biden administration are all in a partnership. It's not written in a contract, but that's what's going on. So that makes it really challenging for states that are trying to protect the border and trying to protect their people from all of these social problems.
So the immigration component is, if I understand it correctly, the immigration component is clearly defined by President by statute as a federal responsibility. Is that correct? The immigration component.
And the court cases, and correct me if I'm wrong, the court cases have largely said that, with the one that we just talked about, U.S. v. Arizona, being the sort of preeminent case decided during the Obama administration. So that's been the one that I think they decided wrongly, and because I can't believe that states can't protect their citizens from crime. That's what we're talking about.
So if I talk about now moving to crime, thank you for segueing to that.
Yes.
The criminal component is where if we mirror federal criminal law, for example, state law, is it your experience that most of the time the federals don't fight that because it's not more restrictive than theirs, but the same, and so what commentary you have?
Yeah,
to say
typically we're able to enforce state law. If we have a crime that's committed, we have our own state laws that would be hard for them to preempt. Because we've had state law that those crimes affect everybody, not just illegals. If you commit that crime, whether you're a citizen or a non-citizen, you're still committing a crime. So we can enforce those laws, but after we've enforced that law, held them for trespass, whatever it is, when it's over, then we transport them back to the feds, and then it's another fight we're in. Because one of the things we fought them over is allowing criminals to come from not just here, but from other countries. So these countries are incentivized to get rid of their criminals and send them to our border, because the Biden administration is not even enforcing the issues as it relates to criminals. So we've got an injunction right now stopping them from releasing criminals into our country, but that's what they're trying to do. And these other countries are, as quickly as they can, taking the worst people they have and sending them to the border and hoping that we get them. And the Biden administration say, yeah, keep doing it. We'll try to get them in. That's the truth.
So if we enact state law that mirrors federal law that they're not enforcing, but we enacted a state law which has a mirror federal criminal law, would you think that would be effective?
I think it would. Ben, you have a comment on that?
As a general principle, yes. And then the question becomes whether someone brings an Arizona v. United States style challenge, saying either that this is if the state law mirrors the federal law exactly, it would probably be a so-called field preemption challenge, where someone says the federal regulations so occupy the field that the state cannot regulate in this area.
Yeah,
as a general
yeah,
principle.
it would kind of depend on what it was, and I'm not saying we wouldn't win, even if it mirrored exactly. I'm not sure, because of where we're at today versus when that case was decided. The fact we've got different justices on the court. I mean, it's not. I'm not saying it's an easy fight, because Justice Roberts, he was on the other side, and obviously Justice Kennedy is gone, but Justice Roberts has an incredible influence on where those cases go. We've looked at our odds when Justice Roberts is not with us. I mean, he's on the winning side about 95% of the time. So we pay attention to what he does.
Thank you, Mr. Chairman. We have a number of bills in the works right now. I know myself and Senator Hinojosa have a racketeering bill.
Well, we're so happy to work with you. If you need help or guidance, we'll give you our best, given that this is a evolving sort of uncharted territory kind of area, and we're just doing our best with what we know.
Well, thank you. We appreciate your guidance and leadership in working with us to be able to craft something that will be immediately effective.
Yep.
And something that will survive court scrutiny.
Thanks for your great work. Appreciate it.
Okay. Excuse me, let me come to Senator Hinojosa first, if I may. Senator Blanco, Senator Paxton, as soon as we're done with your husband, we will get to you. So please sit tight. I know you got other committees, but you'll be first up after our time with the Attorney General. Senator Hinojosa, you're recognized.
Thank you, Mr. Chairman, and good seeing you again, General Paxton.
One of my favorite chairmen of all time.
You serve my committee. Let me. I know there's no doubt that we face many challenges along the border. We are now having immigrants come from all over the world. They're now the majority of immigrants not from Mexico. And Mexico identifies more with Texas culture than some of the other immigrants coming from Central America,
That's correct.
South America, Africa, Middle East, and other European countries. And the challenge we face, usually when we have a situation where a whole family comes across, we take care of them. We feed them, clothe them, what have you. And I won't go into a lot into the weeds because we know some of the issues that exist. I live on the border. But within the group of immigrants that are coming across, I said this again and again. I've seen the evidence. I've seen the documentation. And maybe the majority are coming here to look for a better life. But even then, we cannot take everybody in the world, even those looking for a better life. The problem and the challenge we face that within that group, now the majority seems to be single males. And within that group of single males, there may be a few that are all coming to America to look for a better way of life. But within that group, you have many cartel people. You have many people who've been on gangs, from Sartucha gangs, from all over, not only Central America, but from all over the world. These are criminals that are coming here for a better way of life. They're coming here to commit crime. In addition to that, we have issues with people that we have reported in the past, and they came right back. And I know the federal government is overwhelmed as they were too slow to move when there was a tremendous increase. And we along the border have to deal with this. But what is happening is you have a lot of catch and release. Right? We catch them, we provide them a legal document, the federal government does, for them to travel anywhere in the United States, to show up at a hearing a year hence or two or whenever. The majority don't show up. They get lost within our population. My point is, when you talk about invasion clause, trying to invoke the invasion clause, I really don't think that's the answer. I think we need to provide and shore up our law enforcement forces along the border. Not only our local police, our sheriff department, our DPS, and we're trying to do that. I think the government continues to also increase the number of border patrol agents, if you will, but not fast enough. So I mean, I look at that as a challenge, and I don't. And I know the Arizona case. There's been a lot of controversy about it, and there've been several nuances in court rulings that sort of give a gray area of interpretation. And maybe we do need another case to go up to the United States Supreme Court so we get better clarity on that as to the authority of state rights of states to protect their citizens versus the federal government, who may be lacking and not as focused as those border states are, who are down on the ground and see the everyday issues and challenges that we face along the border. But my point is, I'm not sure that invoking the invasion clause is not the answer. I think the answer is just trying to, as Senator Flores and I were talking about, racketeering legislation to be able to easily prosecute some of the people coming across that are committing crimes and coordinating and cooperate with each other, having to focus on also providing some authority to some of our federal agents to be able to refer cases that they cannot arrest because they don't have the authority, or at least the federal crime is not anywhere near that they would prosecute, the federal courts will prosecute. There are a lot of ways to try to focus on this and provide a stronger border security effort with our local and state law enforcement. I mean, it's just my thoughts on that.
Well, Senator, I applaud you for you and Senator Flores for trying to do. I think you're on a very good path, and I suggested, we'd be happy to help you in any way we can, because I think you are looking at practical ways to make a difference, and I think that's one of them.
And one of the things that we have done also with human trafficking and smugglers, we have made it easier for our prosecutors, district attorney's offices, to prosecute people who are smuggling, who are smugglers and involved in human trafficking, by sometimes changing the elements that are required to prove that crime, because some are impossible to prove when you're dealing with immigrants that are being smuggled and involved in human trafficking. But anyway, thank you for your testimony.
Yeah, thank you.
Thank you. Senator Blanco, you're recognized.
Thank you, Mr. Chairman. I want to go back to the invasion clause, because I think that's an important part, and I think the context is important. When we're looking at when the founders were writing the Constitution, that was obviously it was in the 18th century. Our immigration laws weren't written until the 20th century. In fact, the Border Patrol didn't even exist until 1920, right? So as you're approaching these cases, these court cases, I guess I'd like to get your philosophy on whether or not the Constitution is a living, breathing document that changes meaning over time, or is your office's approach prescribed to the original meaning of the Constitution and the founders?
Yeah, that's a great question. Definitely, if it's a living, breathing document, we don't really have a constitution. It's just whatever people make up at the time, usually meaning a few judges get to decide what we have to do. And so I certainly got that concept in law school at the University of Virginia, which was obviously founded by Thomas Jefferson. I never bought into the living, breathing idea, because then the power resides with just a few. If we have a written document that actually means something, and it means what it was meant to mean at the time, then we actually are protected. All of us are protected. And so I've always viewed it as a document that we should try to interpret as it was written. If people in our time want to change that, there's a process to do that. If it's a living and breathing document, then none of us have a say. It's just a couple of people telling us that this is a new interpretation that I am coming up with because I think it's better for you than what they wrote. And so we're pretty much on to, I don't get to decide what that is. It's whatever we do our best to try to figure out what did it mean when it was written and try to enforce it the way it was written, not what I think it is.
Thank you very much. Appreciate it.
Sure. I should note by me being here, you're holding up you've got the better looking, smarter Paxton waiting.
Would you like to revise and extend his remarks, Senator Paxton?
Can that be put on the record?
I don't see any other lights, so thank you for joining. I'll give you a closing comment if you wish.
Yeah, I really appreciate what you're doing. It's a horrible problem that we're dealing with, and we deal with it every day in my office. I think the thing that is hardest for me to deal with is just watching these kids die. And I've been down to the border many times. I've talked to people that are affected, and it's hard for them. It's hard for them to deal with safety and feeling safe on their own property. A lot of these people are moving because they don't feel safe. And I appreciate that you all are wrestling with some very difficult issues, trying to make it better for Texans. So